breaking news that is sending absolute shockwaves through Washington, through state capitals, and through every corner of the American legal system right now. The Supreme Court has just issued a unanimous ruling, and when I say unanimous, I mean all 9 justices standing together in complete agreement on one of the most explosive firearms issues this country has faced in decades. A 9-0 decision on any Second Amendment case is almost unheard of. These are the kinds of cases that typically split the court right down ideological lines, with fierce disagreements and biting dissents that make headlines for weeks. But not this time. This time, every single justice, from the most conservative to the most liberal, looked at the issue before them and reached the exact same conclusion. This is what legal experts are calling a constitutional earthquake, a moment that the federal government, state officials, and gun control advocates never expected and certainly weren't prepared for. Federal agencies are stunned, scrambling to figure out what this means for their enforcement priorities and regulatory strategies. State officials across the country are in emergency meetings trying to understand how this ruling affects their laws and policies. The media is melting down, with some outlets celebrating this as a historic victory for constitutional rights, while others are sounding alarms about what they claim are devastating consequences for public safety. And millions of gun owners across America are cheering, sharing the news, and recognizing that something fundamentally important just shifted in their favor. So what exactly did the court block? All attempts at firearm confiscation, dead on arrival. Every legislative scheme, every regulatory framework, every enforcement mechanism designed to seize firearms from lawful owners just ran headfirst into a constitutional wall that 9 Supreme Court justices built together. This is the first ruling of its kind, a clear and unambiguous reinforcement of constitutional protections that fundamentally alters how future cases will be decided and how governments at every level must approach firearms policy. What this means for the next phase of the national gun debate could change everything we thought we knew about where these legal battles were headed. Let me break down exactly what just happened, because you need to understand the specifics of this ruling to grasp why it's so significant. When we talk about confiscation attempts that the court just blocked, we're referring to a wide range of government actions that have been proliferating at both state and federal levels. We're talking about state-level seizure programs that allow law enforcement to take firearms based on sometimes minimal due process protections. We're talking about emergency confiscation proposals that use crisis declarations to justify removing firearms from citizens who haven't been charged with any crime. We're talking about federal enforcement efforts that were exploring new ways to compel firearm surrender under various regulatory theories. And we're talking about broad categorical bans that were specifically designed not just to prevent future sales, but to force existing owners to either surrender their legally purchased firearms or face criminal penalties. The legal question that the Supreme Court actually answered cut right to the heart of constitutional limits on government power. Can the government, whether federal, state, or local, implement systems that result in the confiscation of firearms from law-abiding citizens without violating fundamental constitutional protections? And the court's answer, delivered with perfect unanimity, was absolutely not. The justices agreed across the board that these confiscation schemes violated due process guarantees that protect citizens from arbitrary government action. They violated established precedent that the court itself had set in previous Second Amendment cases. And most fundamentally, they violated core constitutional protections that place strict limits on government power to deprive citizens of their rights and property. This ruling isn't just deciding one case or affecting one jurisdiction. This is precedent-setting law that every court in America, from local trial courts all the way up through the federal appellate system, must now follow. And here's what makes this even more powerful. Now let's talk about why this decision was 9-0, because understanding the dynamics behind the scenes at the Supreme Court reveals just how significant this moment really is. You have to appreciate that this court includes justices with dramatically different judicial philosophies, justices who were appointed by presidents from opposing parties, justices who regularly disagree on fundamental questions about constitutional interpretation and the role of government. On most Second Amendment cases, you would expect a 5-4 or 6-3 split, with the conservative justices forming the majority and the liberal justices dissenting with arguments about public safety and reasonable regulations. But not here. Not on this case. Even the justices who have historically been more sympathetic to gun control arguments, who have written opinions allowing for substantial government regulation of firearms, looked at these confiscation attempts and said this goes too far. So what brought them all together? The key argument that unified the entire court was the recognition that confiscation represents a direct and existential threat to constitutional limits on government power. It's not just about the Second Amendment in isolation. It's about whether the government can identify a constitutional right, declare it problematic, and then create systems to effectively eliminate that right for broad categories of citizens without providing the rigorous due process protections that the Constitution demands. The majority opinion, though unanimous and therefore not technically separating majority from dissent, was nonetheless forceful and definitive in its language. The justices didn't leave any room for ambiguity or alternative interpretations. They spoke with one voice to establish a clear constitutional line that cannot be crossed. What's particularly striking are the surprising alliances that formed to create this unanimous front. Justices who typically find themselves on opposite sides of contentious issues joined together because they recognized that the principles at stake transcended normal ideological divisions. And this unified position sends an incredibly powerful signal to lower courts across the country. When a district court judge or an appellate panel is evaluating a firearm regulation and they see that the Supreme Court ruled 9-0 against confiscation schemes, that unanimous precedent carries enormous weight and makes it very difficult for lower courts to uphold similar laws. Here's where the tension really builds. Government lawyers at both federal and state levels did not expect a total rejection like this. They anticipated maybe a narrow ruling, maybe a remand for further fact-finding, maybe a split decision that would leave room for modified approaches. Instead, they got a complete constitutional shutdown. So what does this ruling actually change right now, today, in the real world where Americans are living under various firearms laws and regulations? The immediate impact is massive and multidimensional. Every confiscation-oriented proposal that was working its way through state legislatures or federal regulatory processes just lost its legal foundation. Lawmakers who were drafting bills to implement mandatory buyback programs or seizure mechanisms are now looking at legal language that makes those proposals essentially dead on arrival. Current enforcement programs that were already underway, where governments were in the process of confiscating firearms under existing laws, those programs are being halted or frozen as officials scramble to understand whether their actions are now clearly unconstitutional under this new precedent. States that had implemented policies allowing for firearm removal under various emergency or protective order systems must now adjust those policies to ensure they don't violate what the Supreme Court has unanimously declared to be constitutional requirement. Law enforcement agencies across the country are receiving immediate guidance from their legal departments about how this ruling affects their authority to seize firearms and what procedural protections must now be in place before any confiscation can occur. Gun owners who were living in a state of legal uncertainty, particularly in jurisdictions where the boundaries of confiscation authority were ambiguous or being actively litigated, those individuals have just regained constitutional protections that are now backed by the highest court in the land speaking with one voice. Let me give you some real-world examples of what this means practically. Court-ordered seizures that were happening based on ex parte proceedings where the gun owner never got a chance to present their case. Those procedures are now constitutionally suspect and will likely require significant due process enhancements. Emergency removal attempts under red flag laws or similar statutes that allowed firearms to be taken first with hearings scheduled for later, those frameworks now face serious constitutional questions about whether they provide adequate protection before depriving citizens of their right. But the immediate impact is just the beginning. The massive national ripple effects of this unanimous decision are going to reshape firearms law and policy for years, possibly decades, to come. Think about how this affects future legislative attempts to regulate firearms. Every lawmaker who wants to propose new gun control measures now has to consider whether their proposal could be characterized as a confiscation attempt, because if it can, they've just seen what the Supreme Court will do to it. This creates a new calculus where even politicians in deep blue states with strong gun control constituencies have to think carefully about whether their proposals can survive constitutional scrutiny under this precedent. Now, will some states still try to push new strategies that attempt to work around this ruling? Absolutely. We're already seeing legal teams in various state attorneys' general offices exploring whether they can craft regulations that achieve similar practical effects to confiscation without technically triggering the constitutional problems the court identified. They'll try narrower targeting, they'll try different procedural frameworks, they'll try to distinguish their proposals from what the court struck down. But every one of those attempts now carries significant legal risk because the Supreme Court has established a principle, not just a narrow technical rule. Federal agencies must also completely reinterpret their regulatory authority in light of this decision. The Bureau of Alcohol, Tobacco, Firearms and Explosives, the Justice Department, and other federal entities that have been exploring expansive theories of their power to restrict or seize firearms now understand that there are constitutional limits that the Supreme Court will enforce. They're analyzing the opinion to find potential openings. They're developing new messaging strategies to maintain public support for restrictions, and they're preparing to fund litigation that tests the boundaries of this ruling. On the other side, gun rights organizations are preparing to use this precedent as a battering ram against laws they've been challenging for years. And if you think the legal earthquake was dramatic, wait until you see the political firestorm that's already beginning to rage across the country. The immediate political reactions have been explosive and predictable in their intensity, if not their substance. You've got legislative panic in state capitals where lawmakers who built their political brands on gun control are now facing the reality that their signature policies may be unconstitutional. The court's decision has answered one major question, but it's also raised dozens of new ones that will fuel litigation for years. The next phase of the legal and political battle is already forming behind the scenes, with lawyers on both sides preparing test cases, legislators drafting new bills they hope can survive constitutional scrutiny, and advocacy organizations planning long-term strategies. This ruling doesn't resolve the gun debate in America. What it does is intensify that debate by establishing new constitutional boundaries that both sides must now operate within. So let's talk about the final stakes here, the ultimate significance of what we've just witnessed, and the cliffhanger question of what happens next. Take a moment to absorb the historic nature of a 9-0 firearms ruling from the Supreme Court. In the modern era of constitutional law, particularly on issues that touch hot-button political debates, unanimous decisions are vanishingly rare. When you get one, it signals something profound about how the court views the issue and the constitutional principles at stake. This isn't a case where one side barely scraped together a majority. This is the entire court speaking with one voice to establish a principle they all agreed was fundamental and non-negotiable. We need to frame this as the turning point it really is. The Supreme Court has provided constitutional clarity on confiscation in a way that removes ambiguity and establishes a bright-line rule that governments cannot cross. Federal restrictions on firearms, particularly those that involve taking property from lawful owners, have been significantly weakened because any such restriction must now survive the scrutiny of a precedent that commands unanimous Supreme Court support. States that had been pushing aggressive confiscation-based policies are being forced to retreat, to reconsider, to find new approaches that don't trigger the constitutional problems the court has identified. But the aftershocks haven't even begun. The secondary effects, the follow-on litigation, the political responses, the attempts to comply or circumvent, all of that is still coming. This is the beginning of a new chapter in the fight over firearms in America, not the end. And how that chapter ultimately gets written will depend on decisions made in courtrooms, in legislatures, in regulatory agencies, and in the court of public opinion over the months and years ahead. This is the moment. This is when everything changed. And what comes next is going to determine the future of the Second Amendment for a generation.